Good morning, children. Hope you all must be fine. Now, on our this particular morning, we are going to discuss legal studies under the unit judiciary. Today, we'll be discussing salient features of Indian judiciary. Fine, children. We have discussed so far the different topic like structure and hierarchy of courts in our country. We have discussed about the Supreme Court in detail. We have discussed about High Court in detail. We have discussed about District Court and the lower courts, municipal courts, and about tribunals we had discussed in detail. Now, any question, if you want to ask, you are free to ask, you must ask, and it must be a two-way traffic, what I believe, children. As per our plan, today we must take up the new topic, that is salient features of Indian judiciary. Under this, the two basic topic what we are going to discuss is India as a common law jurisdiction and adversarial model of dispute resolution. Along with adversarial, certainly we would be discussing about inquisitorial model of dispute resolution. Yes, children, these are the two main methodology, two main models of finding the solution of any dispute, outstanding disputes between the two parties, between the two countries, between the two communities, in fact. But basically, here we do have the nation. Some nations they follow the adversarial model of dispute resolution, and some nations follow inquisitorial model of dispute resolution. Same we are going to discuss in case of a common law jurisdiction and civil law jurisdiction. Very simple term, means the country that used to follow the system of or jurisdiction of common law, and the country that follow the system of the jurisdiction of civil law. Fine, children, we must proceed further. And while discussion is going on, any question that you come across, you must ask. As per the important features of our judiciary, the Indian judiciary, whenever we are discussing about Indian judiciary, one thing we must keep in mind, that the way judiciary is impartial, judiciary is independent in our country, rarely we find that in any other countries of the world. Fine, children. So, as per the important features, salient features of our judiciary, we had very first thing that see, British had ruled over us for more than 200 years. So, some positive aspects what we wanted, that this style British adopted, British succeeded. We, under a democratic setup, if we wanted to succeed and we found it suitable for our democracy, for the betterment of the country, we adopted it. So, certainly the precedence we have taken from the British tradition of common law. British used to follow the common law. So, India also decided to adopt a similar model, the common law jurisdiction. Because we adopted common law jurisdiction, so India is known as a common law jurisdiction nation. Under this scheme, under this system, you must be wondering that what are the importance or the basic features of this common law jurisdiction. And for the very basic reason India decided to adopt it, that the decisions under this system, common law system, the decisions, orders and judgments developed by judges in our country, they can develop, they can give decisions, they can order, they can give judgments, okay. And it also helps us in many ways, like in the creation and development of laws, in creating laws, in developing laws. Certainly the law members, the members of jury, the jury members, the judges, they are having this right in our country. In the sovereign, socialist, secular, democratic Republic of India, judges are entitled to do so. Simultaneously, it also helped It means that under this law system, the decisions, orders, and judgments developed by judges in our country help in legal principles also, in establishing different legal principles as well. And thereafter, it becomes binding precedents for all subordinate courts in the hierarchy. For example, and here you need to understand, children, that if Supreme Court has given a verdict, it has become binding for all the high courts across our nation and for all the subordinate courts. If High Court had given, then certainly for all the subordinate courts it had become a binding. But it can be quoted simultaneously to plead any case by the side of any pleader, any lawyer in other high courts and even in the Supreme Court, that one High Court had given the judgment on this basis. But they can't compel that because one High Court had given the judgment like this or based on this thesis, based on this witness or such kind of principle. That's why Supreme Court also need to do that, because Supreme Court is the apex court. Supreme Court, they may change the verdict of High Court as well, but if Supreme Court has given the verdict, then it is binding and it becomes a binding precedence for all subordinate courts in the hierarchy, means in our country. Any confusion, children? You must ask the question. Fine. Now we are moving ahead. The way courts play a very important role, a very vital role, courts play in our country. In creating law also courts play a vital role, especially where gaps in law exist. Means in case of any lacuna, in case of any loophole, courts play a very important role in creating law, and the legislature or executive, means these gaps or lacuna we are talking about here, that courts play a vital role in creating laws, especially where gaps in law exist, and the legislature or executive, they have simply failed to enact laws. They simply paved the way, or it was beyond their control. They couldn't control, they couldn't ponder, they couldn't looked upon it. That's why they, in this case, courts play a very vital, a very important role in creating laws. Fine, children. So apart from administering civil and criminal justice, civil and criminal justice certainly would be administered by the judiciary. But apart from administering civil and criminal justice, courts and judges, they serve a vital function in the federal setup of the country. Here, children, you must need to recall the concept of federalism. Needless to recall you, children, concept of federalism. You are well aware, you have been discussing it since class 10th. Fine. The concept of federalism means the distribution of power, the division of power between the central government and the state government. Fine. It's always a two-way traffic. Central government always cannot go to impose its visage ambition on the state government. Whatsoever is necessary, whatsoever is in favor of the common people, for that central government they can certainly assist, they can certainly request, and at times they can issue the guidelines that state governments need to follow. But in every case, or very simply, central government can't dictate their terms over the state governments. So a federal setup, in ensuring the federal setup of the country, judiciary plays a very vital function as well. Okay. Now, this was about the system, what we say the common law jurisdiction, common law system. Now, children, we are moving to civil law system. Under this civil law system is just opposed to the model of the common law system. Fine. So, as per this civil law system, the concept is that source of law. Basically, the main difference between these two is the source of law, from where the law comes, and the countries that follow, few countries that follow the civil law system, like Russia, like Germany, and some countries of the continental Europe, they also follow it. Okay, so what are the differences between the common law system and the civil law system? You must be wondering and you must be willing to know. Okay, so we are moving to know the differences or the differentiation between the common law system and the civil law system. Under this common law system, children, judiciary can make laws through judicial decisions of the courts, obviously, and under the civil law system, only the legislature or executive has the power. Only legislature and executive are entitled to create laws. Legislature and executive has the power to create law, to make law under civil law system. Try to understand it clearly. No need to get confused that under the civil law system, only the legislature, either legislature or executive has the power to create law. Judiciary can't do that. And under the common law system, judiciary can make laws. Okay. And under the civil law system, legislature or executive has the power to create rules also. Means creation of rules, creating of laws can be done under the civil law system by legislature or executive only, and under the common law system judiciary can also do so. So the salient features of our judiciary, of Indian judiciary, in following a common law model, it further strengthens the role of courts in India. Clear, children? That this common law model, in fact, it keeps strengthening the role of courts. Role of courts are very vital, very important. And in this days to come, we will be discussing about their complete independence, impartiality, or the constitutional safeguards that had been provided. Fine. Now, the second most important concept of today's topic, the differentiation between adversarial model of dispute resolution and inquisitorial model of dispute resolution, children. These are the two types of methods to resolve the dispute: inquisitorial and adversarial model of dispute resolution, children. Fine. Under this adversarial model, courts in India, they used to follow this system of adversarial model of dispute resolution. As we find under this system, that the role of lawyers representing the party, that becomes vital. The way we find that if we go to court, then in any case of ours, for that purpose, we need to go to the court. First thing, we need to hire a lawyer. If I myself, oneself is a qualified lawyer, then one can plead its case. Otherwise, we need to hire a lawyer. Okay, so role of lawyers representing the party becomes very vital, and lawyers of opposing parties, they present their cases before a neutral judge. So judges are neutral, and both the parties, the prosecution and the defense, they will have their own lawyer. So lawyers of the opposing parties, they present their cases before a neutral judge, who in turn provides a decision based on the merits of the case or demerits of the case as presented by the lawyers. Who could give the witness, who could provide the witness, the lawyer of which side succeeded in giving the witness, and the neutral judge weighed it that okay, it is as per the established norm, as per the court of law, and the judiciary is satisfied, the judges are satisfied, the jury members are satisfied, then they will give their verdict in their favor. Okay, so judges are neutral, lawyers of both the sides, they represent their case. Under this adversarial model of dispute resolution, what we find and what we follow in our country, children. Fine. Now come to the inquisitorial model of dispute resolution. It is followed in civil law countries. Just for example, we had discussed that the countries like Russia, countries like Germany, and countries of continental Europe in particular, they follow the civil law system. Here what happens, judges used to be proactive. Now you may ask that what are these proactive roles of the judges? So in this system, they are more proactive in adjudicating the matter. Rather than acting as a neutral judge, they have rights to inquire. They can probe into the matter like a police. Just imagine if judges, see, it has its positive and negative both. In case of the negative, if we see that judges are in the role of a police also, they will do the probing, they are going to inquire. So a question arises and very natural to arise in our mind that can any judge resist their temptation if judges themselves had probed the matter, had inquired, gathered the witness, okay, and then on the basis of that witness has come to deliver the justice? Here the question arises. That's why in our country we decided to go with the adversarial model of dispute resolution. And under this inquisitorial model, they do have the rights, judges, to inquire, to probe the matter. Like a police, they are doing it, children. And the role of lawyers representing the party and the role of judge cumulatively becomes important in determining the manner in which a civil case or a criminal case proceeds. Fine. These are the differentiation between adversarial model of dispute resolution and the inquisitorial model of dispute resolution. Hope the concept must be clear to you. In case of any doubt, you are free to ask, children. And as usual, some assignments are there for you. So, some questions that very simple questions are there. Where did India choose to adopt a common law jurisdiction? Briefly explain the main feature of the common law jurisdiction. Then the countries that follow civil law system. Can judiciary make law under common law system? And then the differentiation between adversarial model of dispute resolution and inquisitorial model of dispute resolution. Hope you must have enjoyed today's class. Have a good day. Thank you.